distinguished guests, and dear students. It's always a pleasure for me to be with young students, particularly law students. And therefore, when I was asked about this interaction to come over to Bhopal, I readily jumped on it, having spent nearly 53 years in education, almost all in legal education. I had the good fortune of contributing to the learning of generations of law students, and I have seen the process of change in lawyering and judging of those with whom I had occasion to interact. I was asked to speak on the vision of legal education for the future. A vision represents a perspective of the future informed by the present and inspired by the past. One cannot think of a future unless one has some idea about the strengths and weaknesses of the education that obtained in the past and is contemporaneously being provided. But the question of writing a vision for a long-term program is extremely difficult because of the exceptional changes and transformation that is happening in society, in the polity, in the economy, in technology, even in the way we think and act. Things are changing so fast. Even the knowledge is exploding. I am told it used to be every 5 years, the knowledge used to be doubled. But today it is perhaps doubling or tripling every 2 years or every year. So given that sort of a change happening, unprecedented changes, it is difficult to foresee what will be the state of legal education, what will be the state of legal profession in 2020, because it's too long a period. You know, even the Planning Commission is finding it difficult to plan for 5 years because they can't think of the state of affairs beyond 5 years. I am told in the Planning Commission they have started preparing year-to-year plan, because by the time they plan for the 5th year, the world has changed, the country has changed, the economy has changed, and all their calculations go haywire. So therefore, the vision that we are talking about is at best 2020, because Dr. Abdul Kalam, in his dream and in his vision, has always talked about India 2020. Therefore, we may perhaps think of the state of law and legal education 8 years, 5 to 8 years from now, though it is very tentative, and what I speak to, according to me, will be relevant only for 2013 and not much beyond. Nonetheless, there is a need for a clear vision of legal education. What are its objects? What are its goals? It seems to me that whosoever planned legal education immediately after the formation of the Republic had not thought about a vision for legal education. It is important that the freedom fighters and the constitution makers have given us a vision for the country. That vision, as we have seen in the forenoon, is captured in the preamble to the Constitution, Part 3, Part 4 and Part 4A of the Constitution, which put together I consider as the soul of the Indian Constitution. So perhaps any vision on any sector of education, health or whatever will have to be constructed in the vision of the constitution makers which is to last forever. You may change the constitution, because as I said, if you were to compare a constitution with a living creature, you can do surgery, you can amputate, but you cannot take away the soul. Then the constitution no more exists. You can create only a new constitution. So looked at from that perspective, our constitution is for several centuries to exist, so long as the country exists. That means it has to serve several generations of people. From that perspective, the values of the constitution will have to be a reference point for structuring or developing a vision for law and legal education, legal profession. As I said in the morning, those values which are reflected in the constitution is that of justice, social, economic and political, equality, particularly of status and opportunity, liberty, question of dignity of the individual, and the unity and integrity of the nation. I am not going into secularism, socialism, republicanism, democracy, and all the other important goals which have been articulated in the preamble to the Constitution. The Constitution has not only set these high ideals, it has also given a roadmap as to how you can move to those ideals. The three wings of government have been asked that in fundamental to the governance of the country are the directive principles of state policy. You cannot have equality for all times through reservation. So you have to necessarily develop the infrastructure for providing equal opportunity to all. And in providing equal opportunity, there are positive duties and obligations on the part of the state to create a good curriculum. Schools have to be set up, trained teachers have to be provided, economic assistance to be given to those who cannot afford to come to the school. That means a total program of directive principles for governance in order to enable equal opportunity. Those of you who have read Article 38 and 39 will recall. It talks about equality in which it did not recommend either an economy with commanding heights for the public sector or an economy guided and geared by the market. Options are available for both. It only has said in Article 38 that the state shall ensure that the economic the resources, natural resources of the community are so distributed to achieve the common good. So whether the spectrum should be optioned, coal mines should be optioned or not, will have to be determined in terms of the constitutional prescription of serving the larger good of the people and not particular individuals. In 39, there is another directive given regarding economic development which says that the state shall endeavor to equalize the income of different people so that equality is achieved. The gulf between the income of different people shall not be such as to invalidate the objective of equality. This is not only with respect to individuals but also groups. So if you closely read the directive principles, even our Prime Minister will give an idea as to whether he should give FDI in retail, in pension, in insurance, whether it is for the common good, whether it is going to make the rich the richer and the poor the poorer. In that case, Constitution forbids him from adopting that. So if you read and discuss about the directive principles, about the fundamental rights, about the fundamental duties, the preamble, you get enlightened as to what India, that is Bharat. You get to understand the idea of Indianness in the Constitution. You don't have to go beyond the Constitution. You have to discuss, interpret and adopt. So ladies and gentlemen, from that background of the constitutional vision, let me paint a vision for legal education. It should necessarily reflect the same values, you will agree. There is no question. What should that be? Naturally, there should be a constitutional culture, a legal culture imbibing the values of the preamble and the directive principles. So that is the objective of legal education. If you cannot have a curriculum which would impart the values that we have discussed in the Constitution, you will not have a constitutional culture. People will disobey. And as Justice Dharmadhikari mentioned in the morning, all that the state will have to do is to punish everything. Everybody making a criminal. Domestic violence, this, that, marriage, you name it. All acts will have to be supported by penal sanctions. That's not the way to govern. Law will have to be willingly obeyed by the people. Then only there can be democracy and rule of law. Only in extreme situations, recalcitrant members will have to be threatened by the law, not to be used, but threat. And in extreme cases, to be used also. Then only there can be rule of law prevailing. So that is the first objective. Inculcate the constitutional values and create a constitutional culture, what we call constitutionalism, to be able to run a government according to rule of law. How far our legal education performs that is open to discussion. A second, naturally you need to create legal institutions, new legal tools and technologies to be able to adjust to the changes and at the same time promote the general welfare through the system of law. So institutional development, whether it is courts, whether it is the technology of adjudication or mediation or negotiation, which will enable people to access justice in reasonable time, at reasonable price. That is the function of the legal institutions. To what extent we are enabling, because to create new institutions to be appropriate to the situation, you need research. Legal education hardly does any research. Again, to quote Justice Dharmadhikari, we blindly copy legislations which were enacted in a different culture, under a different constitution. With the result, there is a dysfunctionality between the constitutional goals and the legal system. So legal education is supposed to remove this dysfunction, disconnect between the constitutional goals and legal education. A third and very important function about which you are all concerned is to train a cadre of legal personnel who will be able to man the institutions and transform India into the vision that the Constitution has developed. So these three dimensions of goals of legal education, if you look into it, the National Law School experiment is not successful in reaching anywhere to achieving all these three goals. We have taken the first step, that's all. Whether it is a right step or a wrong step, we will discuss. So thus perceived, I submit my second proposition to you is that legal education has multiple goals and it has multiple functions and naturally multiple objectives. What has been the status of legal education when we started the journey as a republic and as an independent republic? I don't want to say anything excepting quote the first Attorney General of India, M.C. Setalwal, who was then the chairman of the Law Commission of India. in the 14th report of the Law Commission, there is a paragraph which I will quote to you, which will give you the state of legal education in 1950s till about 1960. I quote, "The main purpose of legal education seems hitherto have been not the teaching of law as a science or as a branch of higher learning, but merely imparting to students some sparing knowledge of certain principles and provisions of law to enable them to enter the legal profession." All that was required to enter the legal profession was a smattering of some knowledge of that theft consists of A, B, C, D elements. So some definitions and some principles was all that was required, for which legal education, some advocates were coming and giving lectures. And this is what he further says. "Nor is the education in law imparted at the universities such as to fit the law graduate even for the profession, notwithstanding its supposed bias in favor of a professional career." And what was the result? Mr. Satalwad says the result was a plethora of LLBs, half-baked lawyers, who do not know even the elements of law and who are let loose upon society as drones and parasites in different parts of the country. The legal profession was a parasitic profession. It was a parasite of the society. Lawyers were liabilities because they were half-baked. They did not have the knowledge and skills to solve the problems in society. That was legal education in 1950s. And I am a product of that education. Well, the first attempt to save themselves out of this situation was made by the Advocates Act 1961. What was the objective of the Advocates Act? At that time, lawyering was confined to litigating. Therefore, the Advocates Act was conceived to produce litigators, adversarial litigators, who were to resolve legal problems or settle disputes by assisting the court. This was the major and perhaps the only objective. I couldn't find any other objective. But another objective that is not connected to the legal education was to unify the bar. At that time, after independence, there was a bar in Madras, there was a bar in Calcutta, there was another bar. In some places, legal education was after school education, pre-university, no degree was required. In some other places, 1 year LLB. Some other, in Pune and other places, it was a 2-year LLB without a basic degree. It was in utter confusion. And a lawyer in one place could not practice in another place in India. So one of the objectives of the Advocates Act was to unify the bar, create the Bar Council of India, entrust the responsibility of admitting people in the profession to the Bar Council, determine the discipline, ethics to be followed in the profession, and look after the welfare of advocates. Along with it, the Advocates Act, perhaps by mistake, has assigned legal education also to the Bar Council. I say it is a mistake because if it were left to the educational institutions, they would have done a much better job than the practicing lawyers sitting in the Bar Council deciding curriculum for the law school. But having done that mistake, the Advocates Act did not change because the Bar Council of India did not allow it to take any power from them. So therefore, a mess was created. But they have done some good things also. The good thing that they have done is to make legal education a postgraduate degree after a first degree, and the duration of which was determined to be 3 years, not 1 year or 2 years as it existed, but 3 years uniformly in India. And additionally, with the help of the Legal Education Committee, they decided a core curriculum which need to be taught in every law school. You may teach many other things, but this core curriculum of 12 papers ought to be taught. But beyond that, they did not do anything because they felt that what is studied in the law college is not very much relevant in law practice. So the Advocates Act said that there must be a 1-year apprenticeship compulsory under a senior advocate, and you have to pass an examination conducted by the Bar Council on procedural subjects before you can be licensed to practice. That was the scheme of the Advocates Act. But because of some strike by some lawyers, by some law students, the Advocates Act was amended and the requirement of apprenticeship and bar examination was deleted. That is the road to disaster. So anyone and everyone coming from whichever place, and law colleges were run indiscriminately. In the state of Madhya Pradesh, I have counted 87 law colleges at one time. And many of those law colleges situated in places where there was no court, no advocate. An advocate from the neighboring taluka used to come occasionally when he pleases and give lecture to all the students together. First year, second year, third year, come on, we will have some law lectures. And people hardly came for the law classes. No attendance requirement. And when the examination comes, mass copying was the order of the day. So if it was mass copying by the student themselves, one can understand. But somebody else came to impersonate them and copy for them also. Because the student doesn't know whether it is criminal law or family law, which book to look at. Such was the state of affairs. I don't joke. I'm exaggerating a little, but I'm not joking. This is if you look into the Public Service Commission, where lawyers are interviewed, the records of the Public Service Commission show a question was asked to a law graduate who was practicing for several years. What are the subjects you have studied? He could not count more than 3. He could not say what more than 3 subjects. This was when I was in the civil service examination. This was pointed out to me. Well, therefore, ladies and gentlemen, it was a bad state of affairs. But one thing has happened. Prior to independence, the legal profession was largely managed by the upper caste, the Brahmins. The other castes were not generally entertained in the legal profession for 2 reasons. One, the barristers were controlling the legal profession largely, and many who could afford to go to England were bar at laws, and they were far superior. The local people were muktiyars or agents or people like wakils, people like that who were having some knowledge of the law and acted as some agents in small cause courts. But access has come in a big way, so much so the first generation learners had come to law schools whose parents had never gone to college. It's a good thing. Many women started coming. Otherwise, prior to independence, hardly any woman was in the legal profession. But women, poor people, villagers, they were all able to come to legal education because the fee was only 10 rupees, 5 rupees. That was also not very particular. You may come, you may not come. Attendance was not very strict. You may copy, you may not copy because examinations were not strict. And as usual, therefore access, yes, inclusiveness, yes, but the consequence was the quality has gone out of the window. And we were producing graduates in thousands and thousands. With the result today, we have 1.3 million advocates according to the Bar Council statistics, which is perhaps the largest. Even America could not cope up. They have only 1.1 million. So we are the largest. Of course, we are the largest country. We have 1.2 billion people. Why not? But how are these lawyers making their living? How are these lawyers assisting the litigation or dispute settlement or delivery of justice. I have recently written an article in the Hindu newspaper that the legal profession is like a pyramid. On the top are Sorabjis and Narimans and Venugopals and Ashok Desais and Harish Salves, unlimited money. One appearance, 10 lakhs. A month, I am told that the highest taxpayer in India today is Harish Salve. He has this year filed an income tax return where he is paying the exchequer about 100 crores. Not even Amitabh Bachchan or Aishwarya Rai, nobody, no way. So such highly paid profession. In terms of respect, they command great respect for whichever party. Independence, they are their own bosses. Even the CNN, IBN are running after them to speak for 5 minutes to them. So the respect, status, money, independence, everything that one would love is there on the top lawyers. Then you come to the middle, there are people who are after political parties. Some are of course good lawyers working hard to make it a reasonable living, but others who are after political parties appoint me as a public prosecutor, appoint me as a government pleader, give me in the legal panel of this bank or that bank or this, all sorts of methods whereby they try to pick up some practice. Then there are some who make a collaboration with corrupt police officials and bureaucrats and try to create litigation and live on that exploitation. So you find in the middle, in the lower portion, I have done a study on the bar for the Bar Council in 1970s. I found that there are advocates struggling to earn 200 rupees a month. A month. This was 1973. At that time, on my statistics, Chief Justice Chandrachud said there is forced labor in the legal profession, bonded labor. That is what he said. How is it? These young people with an LLB degree approach a senior lawyer, and the senior lawyer utilize them to drop his child in the school, to collect the milk, and this, that, and the other. This is forced labor. This is bondage labor, and in legal profession it exists according to Chief Justice Chandrachud. So it is like this, a pyramid. Now you are lucky, you are in national law schools, you are trying to be at least in the middle of the pyramid, if not on the top. There is so much of space available on the top, but these people will not let you go there. The system is like that is being developed. At the same time, outside the urban metropolitan towns or the district towns, where are the lawyers? 70% of Indians live in the villages. Do you mean to say they have no legal problems? They suffer injustice. They are victimized. They are in the hands of Khap panchayats. They are in the hands of the money lenders. Legal needs are unlimited, unmet legal needs of the people of India. This is the disconnect between the Constitution and the legal profession and legal education. Constitution promised so many things for all the citizens of India. But today the legal system exists perhaps for 25% of India's population. And the 75% has no stake in the judicial system of India. If at all they come to the courts, they come as defendants, not as plaintiffs. They come as accused. This is the reason why Maoism and Naxalism and other things are growing from district to district, because the reach of justice, that is law, legal personnel, legal institutions, have hardly reached much of the rural countryside of India. Be that as it may, a sort of a vision has emerged in 1980s, late 1980s in the Bar Council of India. That is where I happen to be associated in the Bar Council of India Trust, and I was lucky that I was asked to prepare a vision for legal education. Ram Jethmalani was the chairman at that time, and the vision that was provided at that time was studying law in social context. If you study law in the context of the American economy or the world markets, and if the market were to give you signals as to what should be taught in the law school, India will be exploited, or Indians will be exploited for a long time to come. You must get the signals from what Arjun Sengupta report has communicated. What did it say? It said 70% of people live with less than 20 rupees a day. It's not a question of where do you draw the poverty line. These are people who are struggling to make a living. Children, 50% of India's children are malnourished. They will never be able to achieve their full potential, even if you give them nutrition and food after they are born. What sort of India we are going to create 10 years from now? These people who are undernourished, most of them will die before they reach the age of 5. Those who survive will be slow learners, poor performers, great morbidity, and such a youth, even if we are the largest youth population, would they be able to contribute to the productivity of the country? So therefore the problems which are crying for legal solutions are too big to imagine. We are not able to do that in making the laws, in creating the institutions, in preparing the legal personnel, because the objective, the vision was not there. The objective were not clear, and we were trying to follow what was being obtaining elsewhere. So ladies and gentlemen, the change, the vision that has come through the National Law School movement is the vision to study law in the context of Indian society. Unless and until a student understands the realities of Indian society, he would not be able to use law for purposes of social engineering. If you are not aware of the principles of economics, production and distribution of wealth, you will not be able to equip yourself with the economic laws, be they contract law, corporate law, tax law, labor law, business law, whatever. If you are not aware about the social reality of family relationships, matrimonial relationships, you will not be able to understand family law. Therefore, sociology is a relevant subject for law study. Similarly with employer-employee relations, criminality in society. How are you going to study crime and crime control without understanding social reality through sociological, anthropological studies? Similarly with political science. Without understanding the nature of power and states of individual relationship, how are you going to build up a system of governance for democracy? So therefore, political science. You will find that studying law in social context is a revolution with a clear vision. It's not the National Law School. It's the idea of integrated LLB. That is integration. Integration of what? Integration of other knowledges about human behavior in society or social reality, integration of those knowledges with law. That is integrated LLB. Unfortunately, we didn't have the materials, the textbooks, trained teachers who could visualize, who could share this dream and create a curriculum and a teaching program to respond to this requirement. With the result, we were confined to one law school, two law schools, so ultimately about 15, 16 national law schools. But the curriculum is now being followed, though it is the teachers are yet not there in many other law schools, wherever. But the idea of social context education is a great revolutionary step in the vision of integrated LLB program. What next? Next thing is by the social context education, what are we achieving? We are achieving increased social relevance to the legal profession or to law in society, increased relevance to Indian society. Students to be recruited early for this professional study. When students go for medicine after higher 10 plus 2, engineering 10 plus 2, all other professions, architecture, why do we wait till he goes for a BA, BCom, BSc and then study law? So it is ideal to recruit students at the age of 17 or 18 when they complete higher secondary, because they will be more motivated. They will be able to put in effort much more than a postgraduate person. So we got talented students, which is another revolution. The vision was to tap talents at an early age, when they can be motivation, when they can be made to work with a purpose. You become more career oriented. You have a clear idea of what you are going to achieve through 5-year long education in a law school. So that is the next. The third is emphasis on education in skills. Skills of communication, skills of language, skills of research, skills relating to mediation, negotiation, advocacy, trial, appellate. Lawyering is a bundle of skills. It's not knowledge of law.